We now call the last case on this morning's docket. This case number 105625, State of Kansas v. Donald Ray Dean.
May it please the Court, Deborah Hughes, Kansas Appellate Defender Office, appearing on behalf of Donald Ray Dean. In this case, Mr. Dean was convicted of 5 counts of sex crimes, 2 counts of aggravated indecent liberties, 1 count of aggravated criminal sodomy, 1 count of rape, and 1 count of sexual exploitation of a child to sort of set the stage. I would like to submit issues 5 and 6, the sentencing issues, on the briefs and on the 609B letter, unless the Court has any questions about those, which I'd certainly be willing to entertain. As well, issue 4, unless I happen to have time, the prosecutorial misconduct issue, I would also ask to submit that on the briefs. So I would like to focus on issues 1 and 2, which are the 6455 evidence issues, and issue 3, which is the testimonial hearsay issue. And I'll start with issues 1 and 2, and the State filed a 609B letter bringing to the Court's attention the recent decision in Prine 2, and I'll admit that affects the issue that was raised, issues 1 and 2, fairly significantly. In Prine 2, the Court held that the 2009 amendments to 6455 apply retroactively. Second, that no limiting instruction is required for 6455D propensity evidence in a sex crime prosecution like this. So our first issue concerns the admission of 6455 under the old standard for intent and knowledge. And our second issue, number 2, concerns the claimed error in the limiting instruction. So Prine number 2 really applies in those to those issues. But the other holding in Prine that I would really like to focus on is harmlessness. So jumping from the merits for a minute and moving to whether or not reversal would be required if there was error at all in the instruction or in even the admission of this evidence. In Prine 2, this Court held that if other crimes' evidence could have been admitted for propensity under 6455D, but was not, and that's our situation here, the State argues it could have been because the law applies retroactively. District Court admitted it under the old standard for intent and knowledge, that any error in admitting it for those limited purposes when it could have been admitted much more expansively doesn't require reversal because it's not harmless error. Because on a retrial, that evidence would come in more broadly for propensity anyway. That's what I would like to talk about. And first, I would argue that the test for reversibility, harmless error, is based on the idea of whether the error affected the outcome in this case, whether or not the error in this trial on this record, if the Court's confidence in that is undermined to such a degree that reversal is required, and not a future retrial. I think in Ward, the Court specifically defined under 6261, the harmless error statute, that an error that affects a party's substantial rights is an error that affected the outcome of the trial in light of the entire record. And again, that language is referring to this case, this record, what happened here. And to ask what might happen in a hypothetical retrial is really outside that standard for harmless error as the language uses it. And so that's the first point.
Exactly what's happening. We're not deciding what would happen at a hypothetical trial. We're deciding this issue under new law. That even at your trial, if the new law had applied, that would not have been error, correct? I mean, that's a little different than saying, well, when it goes back, what might have happened.
The analysis in Prine 2 focuses exactly on retrial. If it goes back, this would be admissible, and Therefore, the outcome would be the same. So that's where I'm coming from on that. In this case, the defendant got the benefit essentially of a limited instruction that arguably he wasn't entitled to under the state of the law as we know it now. But we have to analyze whether that was error under this scenario. And in Prime 2, it was pretty much the same situation. The district court admitted it for those very limited purposes. And this court held it was error. It was error again, just as it was error in Prime 1 to do that, and then moved to that reversibility standard, and then focused on what would happen on retrial. And I would argue that on retrial, although it's certainly a practical reality to say that, on retrial, this evidence would come in and he would be convicted on the basis of it, but can we really say with that level of certainty that standard requires is that is the actual outcome with that sufficient level of certainty? And what I'm trying to say here is that all we can say is that it would be admissible. Its admission would be permitted on a retrial under the statute. But that's not the same thing as saying it would be admitted. And that's where we're getting into, I think, speculation as to what might happen on a retrial. The trial court still has to perform that three-part gatekeeping function for 6455 evidence, even under D. And so there are too many variables at play at a retrial, how counsel might argue it, and particularly the prejudice, weighing the probative value versus prejudice. If we're going to talk about in this case, the district court did not conduct a probative value versus prejudice weighing with respect to the most damaging of the 6455 evidence, and that was the prior conviction. And so, to address your question, even here, can we say whether or not had that evidence been admitted more expansively for propensity purposes as it was obviously permitted to have been admitted, whether or not the outcome would have been the same because the district court didn't actually apply the full three-part gatekeeping function analysis.
Can't we assume, Ms. Hughes, that the district court, even though it didn't explicitly say it was applying that gatekeeping function here, that it did do that in the sense that it did reject some what I would call propensity evidence now, because of its highly prejudicial nature. It did perform that balancing test. So can we assume that it also did that with respect to this evidence that came in?
It did. My recollection of the record is that happened at trial with respect to the videos. I think it was the videos, but with regard to the prior conviction, there was a pretrial discussion of this, and the district court's ruling is sparse. And I think it goes pretty far for purposes of harmless error analysis to just attribute to the district court that it performed that function. There's nothing in the record with respect to that prior conviction I found that even speaks to that there was some kind of consideration of its probative value versus its prejudicial effect, that occurred here.
So if I'm understanding your argument today correctly, and obviously this is a new argument, which is essentially this evidence probably would have all come in depending on that gatekeeping function that you don't believe the court performed here. And but you're essentially asking us to overrule that aspect of Prime 2 where we suggested that the analysis, as far as the harmless error analysis, considers what the law would be and assumes it's admissible on retrial. So you're asking us to overrule that?
Yes. And Prime 2, of course, came through in a 609B letter, and that's why it's sort of a new issue in the sense that
you didn't
it's just a few
respond to
months
that.
old.
You didn't respond to that letter. So this is the first time we're hearing this argument.
Yes, but the state did make that argument in their brief that essentially the central issue that it's not harmless, or it is harmless error.
So just so I'm clear, you're asking us not to assume admission.
Not to assume
admissibility, but
assume
not
admissibility,
admission.
exactly, on retrial, as a factor in the harmless reversibility analysis. But moving briefly to the merits on the 6455 issue, I again would focus on particularly the prior conviction in that case, and the reasons that that the evidence was admitted was to show intent and knowledge and to argue that was error. because intent is not an issue in this case. It was not a material issue. The case law is clear. I believe State versus Dotson is cited in our brief that when the intent is obvious from the mere doing of the acts, and that's what we have here, and the defendant has just denied it and not offered an innocent explanation, the intent is not an issue for 6455 purposes. And so that's where we get to on the merits. It was error to admit it for that purpose under the prior version of 6455.
Can you step back for a minute, because I think I understand your argument, and I think you're applying it to both the conviction as well as the videos that were introduced, the evidentiary videos to show circumstantial evidence. The state makes the argument, or at least they do now in their brief, that those, at least the evidentiary videos, are not, they don't even come within 6455.
Because they weren't evidence of a prior crime. Yes.
Did you address that? I don't think you addressed that.
The
They didn't raise
statute,
it until their brief.
2135-16 is the statute that deals with sexual exploitation of a child, and that's what the state, I think, argues. Arguably, those other videos of the clothed children would qualify under. And the definition there, well, let me back up. It's using a child to engage in sexually explicit conduct, and that includes possessing a visual depiction of a child shown or heard engaging in sexually explicit conduct. Those are the two relevant aspects of that statute that might be triggered by those videos of the clothed children. And we look down at the definition that the legislature's provided of sexually explicit conduct, and it says, actual or simulated lewd exhibition of the genitals, female breasts, or pubic area of any person. And I would note particularly in that definition, the first example of what is sexually explicit conduct is exhibition in the nude. So I would take that to say actual or simulated lewd exhibition of the pubic area of any person. I think a reasonable argument can be made. A state might try to prosecute somebody for those videos based on that.
The young girls in the videos were clothed.
Right, and he was directing them, the videographer was directing them to open their legs, cross their legs, and it focused close in on the crotch area. So I think a reasonable argument could be made that that's sexually explicit conduct, and we certainly know that's the reason the state was trying to use it, was for propensity purposes, to show his intent and in appealing to his prurient interest, which again is another element of most of these sex crimes. So it's close enough for 6455 evidence that it's, I know this isn't the language in our statute, but it's prior bad acts. That's essentially what they're trying to use it for. Now, whether it's a prior crime, I think under the rule of lenity, we sort of have to fall on the side of the defendant here under that reading of the statute, 2135-16. On issue 3 is the testimonial hearsay claim, and that's the admission of the official version from the pre-sentence investigation report on the prior conviction for indecent liberties. The state doesn't argue the merits of this claim because the state relies on McCaslin and Bryant, in which this court said that the issue wasn't preserved because the objection at trial was hearsay, and now on appeal the issue is framed as a confrontation clause violation. I acknowledge that McCaslin would preclude raising that issue, so again I'm going to swim upstream a little bit and argue what this court has heard before, that McCaslin is incorrect. The strict reading of 6455 in this particular situation is just, it's too strict, it's too stringent, an imposition on defendants in this situation or defense counsel. This court, the appellate courts, grant tremendous leeway to the trial court on the admission of evidence, and particularly I'm thinking of the right result, wrong reason analysis, so that the district court doesn't even have to be in the ballpark of the wrong reason or the right reason to be considered, for that reason to be considered and for the case to be upheld on that basis. So with that leeway in mind, I want to compare that then to the extremely strict imposition of 6455 to require for defense counsel a specificity that's arguably unrealistic in the heat of trial.
You mean 404?
I'm sorry, yeah, 6404. I think that's arguably unrealistic. And so when you compare that with the tremendous leeway we give district courts in not even having to be within the ballpark of the right reason as long as there's some right reason for it, but on the other hand, we draw the specificity requirement for the objection so narrowly that testimonial hearsay is not encompassed within a hearsay objection.
Could you, just in terms of the factual statement that was read, that was generated from a pre-sentence investigation full version? Do you know, I don't know if it's in the record anywhere, but where the pre-sentence investigation got its version? Was it, I mean, the underlying crime, was it a plea, or was it a trial, or do you know?
There was a guilty plea. The Exhibit 1, State's Exhibit 1, I think this is in Volume 19, states that it was a guilty plea to the complaint as charged.
And do you know if that was, what was incorporated in the pre-sentence version was the factual statement read into the record as a part of the plea, or was it something that was beyond that?
I can't tell, because what it says is, after it says the defendant entered a guilty plea to the complaint as charged, it then says, statements, affidavits, and interviews indicate that on these dates the defendant did X, Y, and Z. And so it's that statements, affidavits, and interviews that is the testimonial hearsay. We don't even know what it is, and that's what defense counsel objected. He said, this is full of hearsay.
Right.
And we have no opportunity to, he didn't use the words confront, but we don't even know what it is.
And then we don't even know how the pre-sentence investigation writer put together all that information that it ultimately became read into the record of the trial.
Exactly. And so that's the heart of the testimonial hearsay objection.
Actually, the Confrontation Clause violation is simply a consequence of the hearsay, isn't it? And so when we say that you have to object on confrontational grounds, you're saying that you have to say what's wrong with the proffer, which is that it's hearsay, and also what's the consequence, which is a constitutional violation of the right to confrontation.
True. I think if you just stood up and said that's a violation of the Sixth Amendment, if that was defense counsel's objection, that might also not be specific.
Did you have a Confrontation Clause violation that did not involve hearsay?
Not in this situation, I don't think. I think you can have hearsay that doesn't violate the Confrontation Clause, non-testimonial hearsay, but I'm not sure that the converse is true. I think if it's a Confrontation Clause violation, it is hearsay.
Counsel, I see you're out of time. Would you like 30 seconds to wrap up?
I would just ask that the court reverse Mr. Dean's convictions and his sentences. Thank you.
Thank you.
Good afternoon. May it please the court. I'm Lee Davidson. I represent the state of Kansas, the appellee in this case. The conviction here should be affirmed for three reasons. First reason is under Prime 2, any errors in the admission of the prior crime evidence and the limiting instruction are harmless. Second, Dean failed to preserve his Confrontation Clause argument he now forwards on appeal via a specific objection. And C, that the remarks of the prosecutor in closing argument that are complained of now were generally within the wide latitude afforded prosecutors in discussing the evidence, and even to the extent the prosecutor here strayed over the line, Dean fails to show either gross and flagrant misconduct or ill will on the part of the prosecutor. I've agreed in the brief, and I do so now, that the sentence imposed by the trial court here needs to be set aside and the matter reversed for resentencing. I'm going to talk about the 6455 issue, Mr.
Yeah, that's I want you to tell us why it would automatically be admissible under prime 2 when there's other factors besides propensity, besides the reason. In other words, the gatekeeping function requires more than just determining that it involves propensity, doesn't it?
Yes.
And so how can we...
Prime 2 kind of leaves that a little in the open. I think Prime 2, they said, I think you guys, said that it remains to be seen whether the gatekeeping function of the trial court needs to be, still follows under the new subsection. And before I get into that, I do want to point out that here, the court did analyze it under the new statute. And there was extensive motion practice where the parties argued the 6455 issue, and the court, in its ruling, said that the evidence will be admitted for its bearing on any matter to which it is relevant and probative. That was the court's initial ruling, so far so good, I guess. But then when it came time to instruct the jury, the court gave the limiting instruction telling them to consider the evidence for intent and knowledge, which was a little different. In reality here, the statute was brand new. These crimes actually were committed shortly before the statute was amended. This trial would have been shortly afterwards. And I think that the court and the parties were a little unsure of how to handle the new statute, whether a limiting instruction would still be required and what that limiting instruction should look like. And so I think in an abundance of caution, the court gave the limiting instruction. I think the parties agreed on it. That the record reflects that the court said, and we've agreed on, we've come up with a set of instructions with upon the agreement of the parties, or words to that effect. Okay, so does the gatekeeping function still apply under the new subsection? That's what Justice Johnson asked about. And I submit that the trial court still needs to find whether it's relevant, right? That's the first inquiry, always. As far as a further inquiry under the new 6455D, I think that's it, except for do we do the weighing of probative value versus prejudice. Now, if you read the statute, it says subject to the provisions of 445, rather. And, of course, that statute just talks about unfair surprise. And so if you just go by what the statute says, then the court should weigh whether the probative value is outweighed by the potential for unfair surprise. But I realize that this court, in the 6455 context, has gone beyond what 6445 requires, that it has traditionally, since back in the 70s, required trial courts to weigh the probative value versus the potential for unfair prejudice. And I would also would admit that trial courts have inherent authority to govern the conduct of evidentiary proceedings. I would also say that even outside of the 6455 context, courts have looked at the potential for prejudice outweighing its probative value. I think the Leitner case that's cited in Prime 2 actually says that. It says, notwithstanding the language of 6445 limiting its application to undue surprise, a trial judge may, as a rule of necessity, exclude admissible evidence when it is more prejudicial to the defendant than probative of a material issue. So on the one hand, we say, I could argue, let's just follow what 6455 says. It says subject to 6445, done. On the other hand, I realize that there's this evolution of case law that has said that courts can look beyond just simply unfair surprise. And Judge Atchison, in a fairly recent Court of Appeals case, State v. Young, makes an interesting point. It's in dicta, but Judge Atchison says that if the court did not have the ability to weigh the probative value versus prejudicial nature of 6455 evidence, that perhaps the constitutionality of 6455D might be in doubt. That's an interesting point that Judge Atchison makes. So, in the end, I I think probably in an abundance of caution that the court should still do the gatekeeping function, even under 6455D. So that basically means we look at if it's another crime of sexual misconduct and a crime of sexual misconduct is charged, that fulfills one part, and then you look at relevance and probative value versus prejudice. I think if you do that in this case, the inescapable conclusion is that the evidence is relevant under the new 6455D. The evidence here was presented in a short, kind of one paragraph. This is what happened in 1984. This isn't like Prine 2, where you had the previous victim and all the emotion associated with it took the stand and testified to the years of abuse that she suffered at the hands of John Prine. This was kind of a matter of fact. This is what happened in 1984. I think that that's not very prejudicial way to present it, and the probative value for propensity, I think both instances were young girls. And the court here, as Justice Moritz pointed out, did perform a gatekeeping function because the state did have other evidence that the court did not allow the state to get into. There was the two girls that were in the video that was the sexual exploitation charge. At the pretrial motion hearing, the state moved to admit their testimony about all the abuse they suffered at the hands of Donald Dean, and there was quite a few similarities between what they went through and what the victim in the charged case went through. And the court initially was going to allow that, but on second thought didn't allow the state to get into that evidence and simply allowed the state, or permitted the state to admit those girls' testimonies to identify themselves on the video. But yeah, that's me back when I was 4-year-old or 5-year-old. The other
So your
instance,
position is that we should probably assume that the gatekeeping function is still, post-prime, is still within the statute, it's assumed, and that we can perform that function now in doing the harmless error analysis.
yes. And I agree with counsel that the trial court here there was not an exhaustive analysis on the record, but there was quite a bit of pretrial motion practice devoted to this. I know at least the state filed a fairly detailed memorandum about the evidence it wanted to admit and the reasons to admit it. And I think we can assume the court engaged in the analysis. It simply didn't do so maybe as well as it should on the record. On the jury instruction issue, I think that Prine 2 takes care of that as well. I was kind of pleased that Prine 2 kind of came to the conclusion that I did in my brief here, is that if the evidence is admitted for any matter upon which it's relevant, there doesn't seem to be the need for a limiting instruction anymore. And so here, Mr. Dean had a limiting instruction that gave him probably more protection than than the law required, but I think that the jury instruction issue is at best harmless error and should not affect the convictions here. I want to talk a little bit about the video clips. Counsel now argues that those video clips of showing clothed children could be considered sexual exploitation of a child and therefore should be perhaps considered under 6455. That isn't what trial counsel argued. Trial counsel argued that they're goofy videos, that they didn't show sexually explicit conduct. That's what the defense counsel said in this case, and I think he's right. These were videos, and they were important to admit because these videos were found near the videos that were the basis of the sexual exploitation charge. In fact, one set of the videos was in the same container. The other video was in a box in a different part of the room.
What did they add?
They first of all, Mr. Dean said that wasn't that I didn't know I had those videos of those young girls. I didn't take those videos, and these were videos that had his voice on tape, and so the jury would be able to compare his voice on tape to the video of the videographer of the two girls in the sexual exploitation charge. Also, there was one of the videos actually showed Mr. Dean on it kissing a girl, a little girl. And so that would again show, I think it makes it more likely that he took those videos and knew they were there when they were accompanied with videos where witnesses testified that's Donald Dean's voice. And they were found in close proximity to the video, giving rise to the charge. Also, it would tend to show prurient interest that the videos were, I know this isn't a legal term, but they're kind of creepy, the way that the video was trained on the midsection or crotch area of the girls. That one of the elements the state needed to show, at least on the sexual exploitation charge, was that he possessed those with the intent to satisfy his prurient interest. I think that these videos would add to that we have somebody saying, that's Donald Dean's voice on the video directing these girls to cross and uncross their legs as the camera is trained on their crotch. So that was what those videos added to the evidence. And in my couple minutes remaining, I just want to talk about the confrontation clause argument. And as I was preparing for this oral argument, I kind of was regretting not arguing the merits of it. I kind of hung my hat on the failure to preserve issue, but the reason why I did that is that is one thing that's fairly clear here. State v. Bryant from 2002 is directly on point. It says that even though there is admittedly some overlap in the hearsay and confrontation clause area, that an objection on hearsay grounds is not sufficient to preserve a confrontation clause argument on appeal. And then that was only reinforced in McCaslin, where this court just a couple years ago acknowledged that Bryant, even though, again, that there's some overlap, Bryant says that's not good enough, and the McCaslin court held on to that. And so under that clear case law, I believe that that argument that they forward now on appeal was not adequately preserved. If there's no other questions.
Well, again, I'm just curious if you know the origin of the prior crime description came from a pre-sentence investigation synopsis or what?
Yeah.
And you don't know where that synopsis came from?
Just from what it says in it that counsel cited was affidavits, statements, things like
So
that.
the pre-sentence investigator here just kind of summarized what happened here, and that becomes an actual factual basis that's true and reliable for the purposes it was being offered for in this trial? And
That's
there's
what
no way to
happened.
challenge it?
Well,
By saying hearsay?
Well, there was a hearsay exception, though, for it. It was an official record under 6460L. But that's what happened here. That's what I can tell you.
Any further questions of counsel? I see none. Thank you, counsel.
Thank you.
Thank you both for your arguments this afternoon. The court will take this matter under advisement. This time the court is in recess until 9 o'clock tomorrow morning.